Are non-compete clauses legally enforceable by former employers? Imagine leaving a job and then finding out you can't work in your field for a certain period. That's what non-compete clauses can do. But are they always legal? Let's find out. Non-compete clauses are agreements that stop employees from working for competitors or starting similar businesses after leaving a job. They usually specify a time limit and a geographic area. But whether they hold up in court depends on a few key factors. First, the clause has to be reasonable. It can't be too broad or last too long. For example, a non-compete that stops someone from working in any job for 5 years across the whole country might be seen as unfair. Courts look at whether the restriction is necessary to protect the employer's business interests without unfairly limiting the employee's ability to earn a living. Second, the employee must get something in return for signing the agreement. This is called consideration. It could be the job itself, a raise, or a promotion. Without consideration, the non-compete might not be enforceable. Third, the employer needs a legitimate reason for the restriction. Usually, this means protecting trade secrets, confidential information, or customer relationships. If the employer cannot show a valid reason, the clause might not hold up. Fourth, laws about non-compete agreements vary from state to state. Some states, like California, almost never enforce non-compete clauses unless in very specific cases. Other states will enforce them if they meet reasonableness and other legal standards. If a non-compete is broken, the employer can ask a court for an order called an injunction. This stops the employee from working for a competitor. Courts might also award damages if the employer can prove harm, but they generally won't enforce a non-compete for past violations that happened before the agreement was signed. Even after a non-compete expires, employers can still protect their secrets through confidentiality agreements or trade secret laws. These protections often last forever, as long as the information remains secret. Recently, new laws and regulations are making it harder for employers to enforce non-compete clauses. Federal agencies and some states are working to give workers more freedom to change jobs and grow their careers. For employers, it's important to carefully draft non-compete agreements. They need to be clear, fair, and compliant with state laws. Employees should know that signing these agreements might limit their future job options. Sometimes refusing to sign can affect hiring, so it's good to understand your rights. In the end, non-compete clauses are enforceable only if they meet certain legal standards. They must be reasonable, backed by consideration, and serve a legitimate business purpose. Laws are evolving to protect workers' rights and limit overly broad restrictions.